Hello everybody and welcome back to Contract Law for the Law Academy. As a quick introduction, if you want to support this project of education for the subject of law, please consider becoming a channel member. You will have access to a number of additional pieces of content and material, as well as early access to a lot of these videos that will be released on a weekly basis. And generally speaking, the idea here is just that you will be supporting the creation of this new content. Alternatively, if you want to make a one-off donation, please consider using the super thanks option under the video as well. For this video, however, we're going to continue talking about the creation of contracts, and we're going to talk about the concept of commercial agreements and how this relates to the intention to create legal relations. The previous lesson introduced the subject of an intention to create legal relations. We noted that depending on the particular context in question, the court will give more or less deference to whether or not a particular agreement had attached with it an expressed intention to create legal relations. And so really it is the court that has a certain amount of discretion in making a determination as to whether or not an intention to create legal relations existed in a particular circumstance. We noted that when it comes to social context, so when it comes to contracts between friends, between families, the courts will apply a presumption that there was no intention established. And it is then for the parties who are trying to argue that there was in fact a presumption, so that there was in fact an intention, to rebut that presumption, to provide evidence to the effect that there was a presumption to create legal relations. That is how it works when we talk about an intention to create legal relations within the social context. This video is going to talk about the ways in which an intention to create legal relations is examined and viewed within a commercial context, when it comes to commercial contracts between businesses, contracts between private individuals and businesses. So the courts will essentially take the exact opposite standard when it comes to commercial agreements versus when they talk about social agreements. So when it comes to a social agreement, as I've mentioned, there is a presumption that there was no intention to create legal relations. And it is for the aggrieved parties who want to argue that there was an intention to provide evidence to the effect that essentially rebuts that presumption. When it comes to commercial agreements, there is a presumption that there was an intention. So there was an intention, and it is therefore up to the parties who are trying to argue that it wasn't an intention to create legal relations to provide evidence to rebut the presumption of intention. Okay, so when it comes to commercial contracts, there is a presumption of intention. When it comes to non-commercial social contracts, there is a presumption of no intention. That is the distinction between the two. So it is the opposite mirrored approach to that of the social contracts that we looked at in the previous lesson. Let's see how this is illustrated with a case. We have the case from 1925 of Rose and Frank Co. versus Junior Crompton and Bros Limited. Now, the case itself involved a commercial agreement, or a commercial arrangement, should I say, for the sale of paper goods. The parties had entered into an agreement in relation to an office arrangement. The agreement itself included a clause which made it very clear that there was not an intention on the part of the parties for the arrangement in question to be a legal arrangement. So they had an relation. They had an arrangement. They had an arrangement which, by all and large, would look like a contract and would look like a legal contract. But one of the clauses within this arrangement was that the arrangement wasn't legal. It wasn't a contract, and that it was instead just a, quote, honourable pledge. So then the relationship, when it subsequently breaks down between the claimant and the defendant, one of them, the claimant, wanted to sue for a breach of contract. They wanted to sort of ignore the fact that they've said that it wasn't legal, and they take it to court and try and have their day in court for a breach of contract. The issue for the courts was whether or not the specific clause in question, the clause saying that this was not a legal contract, whether or not that would be enough to void contractual intention, despite all the other factors suggesting that a contract has taken place. So, fundamentally, for all intents and purposes, a contract existed in this particular environment, in this particular setting. And so the question here is fundamentally, does the fact that there was one single clause that suggested that there was not a contract void everything else when it comes to specifically the intention? It was held by the House of Lords that this clause did indeed negate the legally binding nature of the contract, of the agreement, given that the courts were looking for an intention to create legal relations. There is an intention on the part of the parties to actually go into a contract, to go into an agreement, and for that agreement to be legal in nature. So if you're looking for intent, if you're looking for intentionality, then a clause that specifically rules out any kind of legal arrangement therefore suggests that there wasn't an intent for it to be a legally binding agreement, and therefore the claimant's claim for breach of contract broke down owing to the fact that there wasn't a contract in the first place. Continuing on then, well, let's think about the case of Kleinworth Benson Limited versus Malaysian Mining Corp from 1989. In this case, we have a contractual intention relates to this idea of something known as a comfort letter. The defendant in this case had been the owner of a subsidiary who was trading in London, the London Metal Exchange. A loan had been issued by the claimant to the defendant's subsidiary, and then when the subsidiary went into liquidation, it went into insolvency and broke down into liquidation, went into bankruptcy, there was this issue of repayments back to the original claimant. In the original agreement, there included this idea of a comfort letter, which is a statement issued by an accounting firm which examining and assuring the financial stability of a company. So the accounting firm looks at the company and essentially provides some kind of statement as to the financial stability of that company. The letter stated that, quote, "It is our policy to ensure that the business of the subsidiary is at all times in a position to meet its liabilities to the claimant." Liabilities, of course, things that it is owed. This is just an ordinary condition within the general rules and the general parts of business. The Court of Appeal held that the comfort letter did not have any contractual effect. And we have this particular quote here to give an instance of what this means and why they argue that this was the case. So they say that, but in this case, it is clear, in my judgment, that the concept of a comfort letter to which the parties had resort when the defendant refused to assume joint and several liability or to give a guarantee was known by both sides at least to extend to or to include a document under which the defendants would give comfort to the plaintiff by assuming not a legal liability to ensure repayment of the liabilities of its subsidiary, but a moral responsibility only. So, in fact, the assumption, the presumption of an intention to create legal relations could not have been relied upon with the issuance of the comfort letter, owing to the fact that there was no legal responsibility, but only a moral responsibility.